Good afternoon, everybody. My name is Eloisa Ayala, and I am the supervising immigration attorney. I manage the immigration unit here at Legal Aid Service of Collier County. Today webinar, we will be discussing immigration relief for victims of crime and human trafficking. We are having some video issues today, so you will not be able to see me, but you should be able to see my PowerPoint presentation. So first, let's look at what a victim is. Here are some of the definitions under federal law. Under the Victims' Rights and Restitution Act, a victim is a person that has suffered direct physical, emotional, or pecuniary harm as a result of the commission of a crime. Under the Victims of Crime Act, also known as VOCA, a crime victim or victim of crime means a person who has suffered physical, sexual, financial, or emotional harm as a result of the commission of a crime. Today, I will be talking about immigration law, specifically when it comes to victims. I will not go into other types of legal fields, such as family law or criminal law, which also has a lot to do with victims of crime. Today is really just about how being a victim of a crime can affect you with immigration in a positive way. Something good out of something bad. So if you think you're a victim of a crime or you are a victim of a crime, there are several ways we can turn that into something good. There are immigration relief options for someone who has been a victim of a crime. First, let's talk about U visas. A U visa is for someone who has suffered substantial physical or mental abuse as a result of having been a victim of criminal activity. Under immigration law, only certain enumerated crimes are eligible to obtain a U visa. As you can see here, there are 31 different types of eligible crimes, such as abduction, domestic violence, rape, murder, stalking, trafficking, sexual assault, abusive sexual contact, felonious assault, or any similar activity in violation of federal, state, or local criminal law. Therefore, eligibility for a U visa is not just for any crime. It must fall under one of these enumerated crimes. The U visa provides immigration relief for victims of domestic violence, sexual assault, or other violent crimes who cooperate with law enforcement in the criminal investigation and or prosecution of the crimes perpetrated against them. The U visa was intended to protect and encourage victims of serious crime to report crimes and cooperate with law enforcement without fear of deportation and to reduce crime in immigrant communities. Therefore, the U visa is kind of like a method for law enforcement to ensure that persons report crime, even if they are scared. So for U visas, the crime must have happened in the United States. It couldn't have happened anywhere else. On top of that, there must be cooperation and investigation with law enforcement. Law enforcement must sign a certificate certifying that you did cooperate, that you had knowledge regarding the crime, and you were helpful. Without the certificate, a case will be rejected. Therefore, it is must to have called the police. It is important for everyone to know that if you are ever in a situation where you're a victim of abuse, you should call the police and know that it will help you in the long run. Do not be scared of, well, if I call the police, they might deport me. This U visa is exactly for that purpose, so that people are not scared of that. The benefits of a U visa are you eventually, first, you are approved and you obtain lawful status and you are given a work permit for 4 years. Once you've had that U visa for 4 years, you can then apply for adjustment of status and become a resident. And also known as a green card holder. After 5 years of being a resident, then you can become a citizen. U visa petitions can also include children under 21. You can include your parents and or your spouse as derivative. And they will also obtain the U status as long as your application is approved. The U visa also waives all kinds of immigration violations. It is a very generous waiver, and it's given out generously by USCIS. What does this waiver do? It means that if you have committed other immigration violations prior to this, the U visa will waive that violation and allow you to become a resident. For example, if you came through the border and without permission and you've been present unlawfully for several years, the waiver pretty much says, we forgive you. You've been a victim of a crime, but we forgive you for that violation. The waiver can waive lots of other violations, such as order of removals, prior order removals, or multiple entries and exits without permission. The way a U visa works is we fill out the applications, we obtain the certificate from either the local sheriff's office who handle the investigation of the crime, or the state attorney's office who is also handling the court case. It gets filed with USCIS along with your waiver. And after that, it's just a wait and see. What's the catch with the U visa? Well, what's the problem? Well, it takes about 5 years to be approved. And while you wait for the 5 years, you do not get a work permit, and you are not under legal status while you wait. It also does not preclude you from being deported or ordered removed. An immigration judge does not consider an application for a U visa as a defense to deport you. Therefore, what does this mean? Well, if you find yourself in deportation proceedings, removal proceedings, and you've applied for a U visa or in the process of applying a U visa, it does not help you. It does not help you in terms of the judge terminating your proceedings. Because the judge knows that these U visas take years, they consider this type of relief very remote, very away in the future. On top of this, USCIS is the agency that adjudicates the U visas, and it's not within the control of the judge. And therefore also another reason why they do not consider it immigration relief as a defense to deportation. There are some exceptions, and mainly it is when a judge sees that your U visa has been pending for several years and you're close to that mark of approval. Let's say you've been waiting for 4 years, you're about 1 year away from having that approval. That judge may allow circumstances, wait, give you time for that U visa to be approved. That way you wouldn't be removed. I hope that made sense. Moving on to the T visa. The requirements of a T visa is that you must be a victim of a severe form of human trafficking. So the T visa is really very specific to victims of human trafficking and nothing else. There are 2 types of trafficking considered by the statute: labor trafficking and sex trafficking. Second requirement is that you must be present in the United States on account of the trafficking, meaning because of the trafficking, you entered the United States, or because of the trafficking, you're now here. The applicant must also show that you would suffer extreme hardship involving unusual and severe harm if you were to be removed from the United States. Meaning that if after being a victim of human trafficking, you must show that if they were to return you to your home country, you would suffer harm. For example, you may say that the perpetrator might harm you back in your home country if you were to return. The next requirement is you must comply with any reasonable request from law enforcement. This is important because it differs from the U visa. As previously discussed, a U visa requires a certificate from the law enforcement certifying that you've cooperated in the investigation. Here, for a T visa, a certificate is not required. You can show that you've tried to cooperate with law enforcement by any other evidence, such as reporting the crime, but you are not dependent on whether an actual investigation occurred. An important fact for T visas is that the trafficking can begin in another country. And it doesn't matter if the victim didn't know what they were getting into. For example, the victim may be told that if they join the person to the United States, they will be given a job and a house and everything will be fine. The victim, believing this to be true, goes into the journey and later finds out they're being held against their will, their wages are being held also, not being given food. So though the victim thought they weren't being trafficked, this would still be a good case scenario for that trafficking victim in terms of obtaining that T visa. The biggest problems with T visa are that most victims of trafficking never report it. So if you don't report it, or if you don't try to do something about it, then you have that problem with showing that you've tried to cooperate with law enforcement. What are the benefits of a T visa? Well, just like with the U visa, once approved, lawful status and a work permit is given for 4 years. After the 4 years, you can apply for adjustment of status and you become a resident, or also known as the green card holder. And 5 years after you can become a citizen. You can also include children under 21, parents and spouses as derivatives, and they would also obtain a T status visa once your main application is approved. The T visa is even more generous than the U visa. The T visa waiver, sorry, is also more generous than the U visa. It also means that you can pretty much waive any other immigration violation when you apply. Well, what's the catch here? What's the problem? Well, actually, for T visas, it is a lot simpler and easier than U visa. There is no wait time. There is no 5-year wait time like with the U visa, though there is a cap of 5,000 visas a year, just like with the U visas. The cap is never met, and that's why there's always visas available, and that means no wait time. Therefore, it can also help you as a defense in immigration court. And it also means you will receive your work permit and your lawful status much quicker. Our next relief is the Violence Against Women Act, and it's also more commonly known as VAWA. To be eligible for VAWA, you must be the spouse, child, or parent of an abusive United States citizen or legal permanent resident, also known as the green card holder. What are the requirements of VAWA? There are 7 requirements. I will go into each one. First is having a qualifying relationship, having a qualifying abuser, having a good faith marriage, a finding of battery or extreme cruelty, having resided with the abuser, having a finding of good moral character, and currently residing in the United States at the time of the application. So first, having a qualifying relationship. What does this mean? Well, it means that you either must be the spouse, or you are the child of, or you are the parent of a United States citizen who is abusive, or a United States legal resident who is abusive. Also, you can be the child of the victim, of the main victim, whether that child was abused or not. They can still petition under VAWA. So going back to the main definition, you must be the spouse, child, or parent of an abusive United States citizen or legal permanent resident. The key word here is United States citizen or legal permanent resident. So, for example, if you're married to someone who is not United States citizen or resident, someone that is not currently under legal status, VAWA would not work, even if you were abused from that person. Then you should be thinking about U visa, for example. But for VAWA purposes, the abuser must be a citizen or a legal permanent resident. And that is when the requirement of a qualifying abuser comes in. Again, the abuser must be a United States citizen or legal permanent resident, though the abuse could happen before the abuser obtains citizenship or residency. The third requirement is having a good faith marriage. This applies only for spousal cases. Obviously, if you're the child or parent of that abuser, it's different. But for spousal cases, the marriage must have been entered in good faith, meaning that you entered the marriage because you actually wanted to be married, or you love that person, or whatever that intention of actually being in a real marriage means, and not for immigration purposes. The other requirement, and one of the most important ones, is being the subject of battery or extreme cruelty. Such examples are threats, verbal abuse, such as calling of names and obscenities, hitting, punching, slapping, emotional abuse, sexual abuse or exploitation, threats of taking your children away or hurting them, threats to deport you or not doing your immigration paperwork, controlling where you go, what you do, who you can see, keeping you home, not letting you go out, engaging of patterns of acts that consider alone, maybe in one time, would not constitute abuse, but put together, it could. Threats or committed acts of violence against a third person or thing. For example, if there are threats against your children, not necessarily against you. However, keep in mind that the abuse must rise to the level of severity to be considered battered or extreme cruelty. Also, examples of non-physical abuse that may constitute extreme cruelty include social isolation of the victim, accusations of infidelity, incessantly calling, writing, or contacting the person, interrogating friends, family members, threats, economic abuse, such as retaining money, not providing nutrition, not allowing the victim to get a job, controlling all the money in the family, or degrading the victim. And this is important because that means that there doesn't have to be a physical abuse in the relationship. It could be through any of this. And most importantly, a combination of this is what would rise to that extreme cruelty. The next requirement is currently residing in the United States. So the petitioner, when the petition is filed, the applicant must be currently living in the United States. There are some exceptions to this, but for a general rule, you apply for a VAWA while you are in the United States. The other requirement is that you've resided or are currently residing with your abuser. So you must have lived together at some point. Under the statute, there's no specific time, doesn't say a year or a month, but you must at least show that you've lived together. For marital cases, the abuse must have happened during the marriage. So the abuse, if it happened, let's say during a 5-year relationship before the marriage, it wouldn't count. It has to be during the marriage. And it's under this requirement, more often than not, we'll see the victims still living with their abusers, and that's okay. And there's also victims who were no longer living with their abusers. And a lot of clients come and ask, well, I'm not living with them anymore. Do I need to be living with them? And no, as long as at some point you live together and you can prove that, you are eligible. The other requirement is good moral character. You must show that you, the applicant, the victim, has good moral character. There's no definition of good moral character for immigration law, but these are generally examples of what is considered not to be good moral character, such as being a drunk, engaging in prostitution, engaging in any other type of commercial vice, such as gambling, involving and smuggling people into the United States, committed acts of violence or moral turpitude, such as theft, being convicted of 2 or more offenses, for which the sentences are 5 years or more, being convicted of or any charge relating to controlled substances. And the list can keep, it's long. These are only some of the examples. There are exceptions also. For example, if, let's say, you were convicted of a drug offense, but that was because it was related to the abuse. Let's say your abuser forced you to use a controlled substance, for example. There are exceptions to that because it was related to the abuse. So VAWA, important fact, again, cannot emphasize it enough. The abuser must be a United States citizen or resident. The biggest hurdle with this type of cases is that they usually fail because they don't have enough evidence to prove that the applicant was subjected to extreme cruelty. Lots of times they can't show that the marriage was entered in good faith, meaning there's not enough evidence that the couple was actually a couple. I know it's kind of hard to explain. And it's also hard to prove sometimes the abuse, especially when there is no physical violence or there is no trace of seeing a doctor from injuries, or there's no reporting to the police done. And like I said before, it's not required to contact the police at all for a VAWA. But that's why it's also very important that you have evidence of the abuse. Obviously, one of the main pieces of evidence is calling the police, but it's not required. So a lot of times we have to get very creative as to how we can prove that abuse. What are the benefits of VAWA? Well, once you're approved, you can apply for your green card right away. Most of the times you can submit your VAWA petition and your application to adjust status, meaning your application to become a resident at the same time. It's pretty fast also, there's no wait time. Eventually you also become a citizen after 5 years. You can also include your children under 21, even if they were not abused. The VAWA petition also has a waiver, and it's also very generous, sometimes even more than the U visa. So it would also waive many of previous immigration violations that could have been committed by the victim. So what's the catch here? What is the problem with the VAWA petition? Well, there seems to be no problem here. There are no wait times. So usually cases under VAWA can be approved in less than a year, meaning you could be a resident pretty fast. No need for law enforcement cooperation. You can apply even if you never reported the abuse. So, and that's one of the key things of VAWA is that there's no need to call the police to be eligible. But again, you have to be able to prove the abuse. And the fact that you don't have to call the police is great. But again, remember, the abuser must be a United States citizen. So it doesn't mean it's easier than a U visa. It's just very different. So we spoke about a U visa, a T visa, and a VAWA petition. All three of these relief methods under immigration law pertain to victims of crime. As we spoke about, a U visa encompasses lots of different types of crimes, not necessarily domestic abuse, as compared to VAWA, which is mainly focused on domestic abuse from a spouse or parent or child. I do want to emphasize with the VAWA that the abuser, though I've been speaking a lot in terms of a spouse, the abuser can be also a child or a parent. So if your parent is a United States citizen and is abusive, or your child is a United States citizen and is abusive to you, it's not necessarily a spouse. But again, they must be a United States citizen or resident. A T visa is more rare because it is specifically to victims of trafficking, of human trafficking. There is one other method I did not speak about today, and that's asylum. We consider that also a method of relief for victims of crime. I just want to say a few things about it. Mainly, in general, those crimes occur outside of the United States. They work very differently than a U visa or a T visa or a VAWA, and it's a lot harder to prove. Asylum is so overbroad that we probably would talk more about it in another webinar so that I could really go into it. If you feel you're eligible for any of these immigration reliefs, please call our office. If you have any more questions regarding as to any more details of each one of these types of cases, feel free to call us. Again, if you are a victim and you find yourself needing help, if you're scared, also please call our offices, and we're here to help. I want to also thank the Southwest Florida Community Foundation and the Unitarian Universalist Congregation of Naples for being sponsors of our immigration unit and continuing to support us in trying to help immigrants in our community. If there are no questions, thank you again for attending, and we will see you again another day.